Okay, lawyers, I want to give you a tip to be a better deposition taker in an expert deposition. And this tip can be applied to pretty much any expert when they give you some BS general statement that they're trying to hoodwink the jury on. And this could be a doctor, it could be a human factors, it could be an economist, it could be, not maybe an economist so much because they're already making assumptions, but an accident reconstructionist, etc. In California, the burden of proof in order for a jury to consider it is if it's a doctor, it to a reasonable degree of medical certainty. But that also is the same as sometimes they'd say more likely than not. To a scientific standard, it's to a reasonable degree of scientific certainty, but also it's synonymous with more likely than not. But don't they sound different? Doesn't one sound much, much more difficult to prove than the other? In reality, they are synonymous. They are the same. Right? So if you use the burden of proof as a follow-up question when an expert is giving you some BS, some general statement, right? And you follow up with the burden of proof, many times they will back off of that. Let me give you some examples. I just had a motorcycle expert in a motorcycle death, and the decedent had meth and marijuana in their system. And they're talking about, well, you're not supposed to have meth, you're not supposed to have marijuana, and that could have impaired them, and that might have made a difference. If I don't follow up, they tell that to the jury, here it is. I said, now let me follow up with the standard. Are you going to tell the jury to a reasonable degree of scientific certainty that the marijuana or methamphetamine in their system would have changed this collision in any way? Well, I'm not going to say that. Done. Out. Motion in limine. Done. A medical doctor. Well, the activities of daily living, the degenerative disc disease, could certainly be a reason for the pain. Doctor, are you going to tell this jury to a reasonable degree of medical certainty that the reason for their pain is not the collision, but the degenerative disc disease? Well, I can't say it to that degree, but it could be. Out. There was a recent case by 3 or 4 years ago, Clink, that has precluded now alternative theories from being presented by experts if it's not to the legal standard. And this is if you try cases and you have biomechanical experts, is how it was excluded. It used to be, a biomechanical expert would say, well, yeah, they hurt their back, but they could hurt their back in this collision or by sneezing or by sitting down or by stepping off a curb or by being surprised or by laughing. And that could have been admissible. But now when you do it to the standard, the legal standard, are you going to tell the jury to a reasonable degree of scientific or medical certainty that the reason they're injured is because they sneezed? Well, I don't know. I don't know that they sneezed. Exactly. Out. Are you going to say to a reasonable degree of scientific certainty that they hurt their back by sitting in a chair? Well, I don't know what they did. Exactly. Out. Right? So you use that standard as a follow-up, and it will eliminate all of the general statements. Well, a psychologist or psychiatrist, their father passed away 3 years ago. And, that's a very distressing thing. Are you going to say to a reasonable degree of medical certainty that their PTSD was due in whole or in part to the death of their father 3 years ago? Well, I just think it's important to note. I don't give a shit. It ain't coming in because you're not saying it to the legal standard. Do you see how powerful that is when you force an answer, and by the way, in a deposition of an expert, they're not represented by counsel. They waive that counsel right. They waive the attorney-client work product right. And if they don't give you a direct answer, then ask them again. Then ask them again. But remember, when you're taking their deposition under the Code of Civil Procedure 2025 and 2034, that they have to present at a deposition, having done all of the work that they need to do up to that point to provide all of the opinions that they intend to render at trial. And so if they don't have the requisite information at the time of the depo and they give you an answer and it has no foundation, or if they say, well, I haven't made a decision yet, or they don't answer the question in their opinion of to a reasonable degree of medical certainty, scientific certainty, then you have a motion in limine to exclude, because you didn't have a reasonable opportunity to cross-examine them on an opinion if they won't give you an answer to the legal or medical standard. So if anybody has any questions, if anybody wants to see any examples, and I've got some doozies, please reach out. My info's in the bio. My info's in the video description. Come on now, experts. Come on now, legal standard.